Good morning. Let us come to order and go on the record. I am Floyd B. McKissick Jr., a commissioner on the North Carolina Utilities Commission, and I'll be presiding over this hearing. With me this morning are Commissioners William Brawley and Tommy Tucker. I now call for hearing docket W-1343 sub 1 in a matter of application of GWWTP LLC for a certificate of public convenience and necessity to provide wastewater utility service to the Gunite Woods subdivision in Dare County, North Carolina, and for approval of rates. Before we proceed further, and as required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has any known conflict of interest respect to the matters relating to this docket. Let the record reflect that I have no such conflicts and that no such conflicts have been identified. On January 11th, 2024, GWWTP LLC, which I will hereinafter refer to at times as the applicant of the company, filed with the Commission an application for a CPCN to provide wastewater utility service to the Gunite Woods subdivision in Dare County, North Carolina, and for approval of rates with confidential attachments. On January 12th, 2024, in docket W-1139 sub 4, the Commission issued an order discharging emergency operator subject to final financial review, appointing new emergency operator, approving increased rates, and requiring notice, and what I will refer to as the EO or Emergency Operator Order. In the EO order, the Commission ordered, among other things, that Envirotech be discharged as emergency operator and that GWWTP be appointed as the emergency operator of the Gunite Woods subdivision wastewater utility system effective January 1, 2024. The Commission also approved provisional rates pending a decision in this docket. As the emergency operator, the applicant serves 38 residential customers in the Southern Shores Landing and seeks to serve customers in the Gunite mixed-use area that is currently being proposed for development. However, at this time, it has no customers. On January 26, 2024, the public staff filed a letter notifying the Commission that the application was complete. On February 2nd, 2024, the Commission issued an order finding the application complete, establishing a sub 1 docket for the CPCN application, closing dockets number W-1139 sub 7 and W-1343 sub 0, and requesting additional information from the public staff. On February 9th, 2024, the public staff provided the information requested by the Commission. On February 14th, 2024, the Commission issued an order scheduling hearings, establishing discovery guidelines, and requiring customer notice. The order scheduled a public witness hearing, which was held on March 18th, 2024 in Manio, North Carolina, as well as an expert witness hearing scheduled for today. On February 21st, 2024, the applicant filed its proposed notice to customers, which was approved by a Commission order entered on February 23rd, 2024. On March 11th, 2024, the applicant filed the direct testimony of Robert Hauser, consisting of 12 pages. On April 2nd, 2024, the applicant filed the response of Robert Hauser regarding customer testimony for the public witness hearing. On April 5th, 2024, the public staff filed the direct testimony of Gregory Rieger, some of which is confidential, consisting of 10 pages. Direct testimony and exhibits of Lindsay Q. Darton, consisting of 35 pages, 1 appendix and 2 exhibits. And direct testimony and exhibits of Q. Finson, consisting of 10 pages, 1 appendix, and 1 exhibit. On April 16, 2024, the public staff filed a verified response to the company's report on customer complaints. On April 19th, 2024, GWWTP filed a motion to extend time to file rebuttal testimony, which was granted by the commission on the same date. On April 25th, 2024, the public staff notified the commission that the parties had reached a settlement in principle and that no rebuttal testimony would be filed. About 11 days ago. On May 6, 2024, the public staff filed a settlement agreement and stipulation, joint settlement testimony of Q. Finson, Lindsay Q. Darden, and Gregory G. Reger, and a motion to excuse witnesses, waive cross-examination, and admit testimony. The intervention and participation of the public staff in this proceeding is recognized pursuant to North Carolina General Statute 62-15, subsection D, and Commission Rule R119, subsection E. That brings us to today. Okay, let's begin. I call upon counsel for the parties to announce their appearances for the record, beginning with the applicant.
May it please the commission, my name is Edward Finley, Raleigh, North Carolina, appearing on behalf of the applicant. All these letters here, GWWTP LLC. And Mr. Bob Hauser is here with me. He's the witness and the principal. And Julie Perry is here for Peden and Perry Consultants, who has helped us put these cases together.
Thank you, Mr. Finley.
Good morning, I'm Gina Holt with Public Staff here on behalf of the Using and Consuming Public, and with me at council table is Public Staff Attorney James Burnett.
Thank you. Are there any preliminary matters that we need to address at this time? One thing I will express on behalf of the commission is when we get in these settlements like 3:30 in the afternoon, the day before the hearing, it really doesn't always give us adequate time to review the details and to go through the appropriate analysis to determine if all issues have been appropriately addressed. And it looks as if 11 days ago, we were advised the settlement would be coming forth. So I would simply ask in the future of both the public staff and Mr. Finley or any other attorneys serving in a similar position that please try to get in these settlements, perhaps as 72 hours in advance, because otherwise there's considerable time spent by our commission staff and by commissioners in preparing for a hearing that otherwise will be unnecessary or only necessary to support the settlement agreement that's been reached between the parties. So on that note, are there preliminary matters that need to be addressed at this time?
Commissioner McKissick, the public staff filed a motion to excuse witnesses, waive cross-examination, and admit testimony. We filed that yesterday, May 6th, and I would like to renew that request. The parties have entered into a settlement agreement and stipulation agreement and have waived cross of each other's witnesses. And the motion includes the excusal of the company witness, Bob Hauser, and public staff witnesses, Quay Finson, Gregory Reger, and Lindsay Darden. And the public staff requests that moves that they be excused from testifying at the hearing and that their testimony and exhibits be admitted into evidence.
Mr. Finley, would you like to be heard?
We support the motion, and Chairman McKissick, I would just say to let you know that although the parties only filed their settlement in the last few hours, it's not because they haven't been working on reaching an agreement and going through the numbers and coming to a rate that the company can live with as it moves forward and go through all the schedules and that type of thing. So forgive us for being dilatory and getting that to the commission, but rest assured that it's not because there wasn't a lot of work being done. Behind the scenes, as an attorney, you certainly know that often it's on the courthouse steps that the final decision is reached.
Without objection, that motion will be allowed. Now, I will say that there are a few commission questions that we have here that perhaps respected counsel can address at this time, because I think that we would like to get these answers into our record to the extent that you're able to do so at this time, notwithstanding the fact that the motion to allow the excusing of those witnesses has been allowed. Okay. And I'll guess what I'll do is go through those particular questions which have been prepared by our commission staff. And I'll also look to see if there are any other questions from my fellow commissioners at this time. And I'll let each party address these particular questions as you might appropriately be able to do so. Some of them would probably be more appropriately addressed to the public staff, some to the applicant. But we'd like to be heard or like to hear from each of you as it relates to those particular matters. Regarding the agreed upon rate case expenses on public staff settlement exhibit 1, schedule 3.2, on line 2, legal fees, an amount of $57,725 is listed. Do these legal fees relate only to the CPCN application, or are the legal fees related to the appointment of the new emergency operator for Goodnight Woods, now known as Southern Shores Landing, also included in this amount?
For the O application.
Those,
And I'll hear from Mr. Finley first.
Chairman McKissick, I have consulted with accountant Perry over here, and she assures me that the EO activity, the legal expense having to do with that, have been removed from the case, and it's only the CPCN costs that are being sought in this docket today.
Those are the only ones.
that's correct.
You agree with that?
Public staff agrees.
And the legal fees that have been incurred in this time frame are, I guess they were all related solely and exclusively to the CPCN proceeding. Is that correct?
That's correct. As you're probably aware, there are all sorts of data requests that have been submitted and answered, and testimony, and there's been a lot of work, but you're correct.
Very good. Now, another question. On line 3, accounting fees, an amount of $11,363 is listed. Could you explain the nature of these accounting fees? Are these fees related to the internal accountants of the company or external accounting consultants? And if so, please explain.
Started as a transfer. All of the accounting fees have to do with the CPCN application, but the case started out as a transfer. We filed it as a transfer application because there was a CPCN outstanding. The owner of the CPCN had left a long time ago, and the public staff requested that we change and resubmit the application as a CPCN application. And that is a reason for accounting for some of the accounting fees.
All right. And is that your understanding as well?
Our understanding is that those fees pertain to external consultants.
External consultants. Mr. Finley, is that correct?
That's correct.
All right. And what is the time period in which these accounting fees were incurred?
Accountant Perry says that the accountants first started working on this case approximately 4 months before the first application was filed, so it was probably in 2022 to begin. We don't have the exact date, but that's our best guess.
Approximately.
Approximately, yes.
And do you have any questions related to that or on behalf of the public staff?
Let me verify that, those dates. confirming the start date.
That's fine. Take your time.
You know, we're having to sort of speak off the top of our heads here, and we understand that you're in a bind as much as we are. And to the extent that you would like to follow up with some sort of exhibit, we'd be happy to provide that.
Okay.
Written answers to your questions.
Sir, are you proposing a late file exhibit as to this question or as to all of these questions which I posed?
Well, we'll leave that with the commission. If you like it, you let us know and we'll try to accommodate you.
Okay, thank you.
Still searching.
Okay,
We can confirm, beginning of 2022.
2022. Okay, very good. All right. The stipulation states the public staff will file accounting schedules detailing the final revenue requirement prior to filing the joint proposed order, schedule of rates, and notice to customers. Could you explain for the record why that information is not included in the stipulation? And then secondly, did the public staff calculate the approximate monthly rates based upon the stipulated rate case expense amount? And if so, what was that approximate amount?
In answer to your first question, the public staff envisioned extra additional rate case expense past the hearing date. Attendance at this company council at this hearing and after the hearing up to a certain amount. And those costs will need to be audited, if you will, verified. So that's why we requested additional time. And when we have a final revenue requirement number, rates will be designed on that final number, which we will file with the commission. As to the rates as of this date,
And I guess the question was, did you take into account also the stipulated rate case expense amounts? Was a part of that question.
I think the short answer is yes.
Okay.
The cap that Attorney Hall was explaining is included in the amounts before the commission.
And what was that approximate amount that you took into account?
It's 2,500
2,500.
additional expenses post like airing and post hearing to draft the joint proposed order and finalize the schedules.
Okay, thank you. Mr. Finley, would you like to be heard as it relates to that question or questions?
We don't need, we don't have anything further to say.
Okay. All right. Well, next is based upon, I guess the earlier comments recommending approval of CPCN. On page 34 of Ms. Darton's testimony and the stipulation, is the public staff satisfied that all ownership documents have been appropriately recorded with regard to the company's ownership and operation of the wastewater system?
yes.
You are.
And in answer to your question, the rate that was anticipated based on the costs, including the $2,500 cap, was $150.38.
$150.38. That supplements your earlier response.
Yes.
Okay. Is that your understanding, Mr. Finley?
That's my understanding, and I will tell you that some of the time that we've been spending the last few weeks and days is coming up with what that rate would be. That's a lot of the negotiation that we'd be going through to get the expenses in the right category. Some are amortized and some are not. So yes, I agree with that answer.
Okay. And of course, I look, Mr. Finley, to you for this response. Does the company agree with the public staff's recommended $100,000 bond for the wastewater operations of Southern Shores Landing?
It is the company's opinion that that bond is steep in light of what we've got here, 38 customers, and the approximately $1 million that have been invested in this system. They've gone for many months with a $90 per month bill to the customers. The emergency operator, Mr. Freed, had a $20,000 bond as the emergency operator. He has forfeited that bond to the commission. So we would respectfully request a lower bond than the $100,000, $50,000, $75,000. Leave that up to the commission, but you know, the emergency operator was getting a rate of $180 per month, and we're down to $150 per month. The company's been losing money. I would say that the company's investment in this system is 100% equity. So it's a safe investment, and we've got a lot of substantial capital behind it. So we would ask for the lowest bond that the commission deems appropriate, $50,000, $75,000.
And would the public staff like to be heard as it relates to this issue that was not addressed in the stipulation?
Yes, that was an oversight. We stand by our recommendation of $100,000, which is in the testimony of witness Lindsay Darden, which was admitted into evidence.
Okay,
Can I make one other point?
sure, go right ahead.
You know, as we got toward the finish line here, so to speak, one of the things that the company agreed to do was to waive the filing of a rebuttal testimony. So we had it all prepared and ready to go and address some of the issues that the public staff raised. But we deemed it appropriate in the end to try to compromise and come up with a position that we could live with, although, you know, whenever you do that, you win some and you lose some, and nobody's particularly happy with the whole settlement. So just to help you put that in perspective.
Okay. And would the company provide the commission an update on the status of the mixed-use development that's currently pending, and based upon information that's available to you today, what is the anticipated timing of that development coming online and being served by the wastewater utility entity?
We plan on getting approvals. We're kind of waiting on this to go back to the town because they want us to have CPCN before we made application. So we plan on making that application for that development late this year.
And when you started, got it passed.
It would probably begin construction in mid-25 and complete in mid-26.
Mid-25, if all the pieces fall into place, and completion in 26.
Into 25, early 26.
End of 25, early 26. The company understands that it needs to go back to the town to get the town's approval to move forward with that part of the development, and the parties in that endeavor have been waiting for the commission in this endeavor to grant the CPCN before we can finalize that extra step to move into that part of the development.
Okay. And while it wasn't addressed in the stipulation, I assume that everybody supports the issuance of the CPCN. Is that correct? You state that on the record.
That's correct.
Is that correct, Mr. Finley?
By all means.
One of the disadvantages of getting in these settlement agreements a little late. Sometimes there are details that may come up. Give me 1 minute, please. And I guess the other question would be, as it presently stands, all the title issues have been taken care of and addressed that need to be addressed at this time so that title is vested
I don't know there was any time issues.
appropriately with the entity.
Everything's in WWTP's name. Some of it has been there for some time, but there are no title issues.
All the title issues have been resolved.
Yes, sir.
Is that under your standing, Ms. Holt?
It is.
Okay. Let me look to see if there are any other questions from my fellow commissioners. Yes, go ahead, Commissioner Burley.
Thank you. And I guess this question would be for the petitioners. As I understand, you've got $600,000 in planned improvements that have not yet been fulfilled. And I was wondering how much of that is to expand the system to support the additional construction versus just to support the existing 38 customers?
Yeah, it would have to be done, Commissioner Brawley, if they never move into that mixed-use development. That's improvements that have to be made. There's capacity, and my understanding is there's capacity in the system of the way it is designed to serve that new development, but the equipment and the facilities need to be improved so that they'll work like they're supposed to before that can be done or anything else can be done as we move forward under the DEQ's requirements.
Okay, as a follow-up, because I noticed on page 6 in section 3 that you're reserving the right to come back on the rates on the 38 if the development doesn't go forward. So there was some concern that you might be transferring all the risk of development on the rest of the property to ratepayers. And if I understand what you're telling me, that if it's just 38 people, you're still going to have to spend the $600,000.
That's correct.
Approximately, yes.
Well,
Or pretty much.
I'm not going to tell them that.
You're not going to tell us what?
The accountant has said that in past cases, when the rates were set, and is not unusual in these cases, the commission will accept an excess capacity adjustment so that it's not necessarily the case that all the investment is recovered as a rate-based item.
Okay, well, we'll deal with that later. I guess as a follow-up question, if the balance of this property isn't developed in the way it is, what is the potential for you serving adjacent properties other than the proposed?
There are other nearby properties.
Mr. Hauser says there are other nearby properties.
But our commercial development is reliant upon this plant as well. So I think there's a very high probability that will happen.
Well, you're dealing with commercial real estate, so you never want to say will. All right. Thank you, Mr. Chairman. That ends my questions.
Commissioner Tucker, any questions?
Yes, sir. Just a couple. Mr. Finley, has the public staff been approached about your question about a lesser bond? And has there been any negotiations with the public staff about that?
No, sir. There has not yet. There has not been any discussion about that yet.
Okay. I guess in lieu of the travails of this system and having call in an emergency operator, I guess the bond was placed that high to make sure everything's covered, although I have reviewed some financials and the new owners seem to be in a position to cover what needs to be done. I guess I don't know if it's proper or not because I'm new, but I'll ask the public staff, is there any consideration for a lesser bond?
Not at this time.
Commissioner Tucker, I will say that the bonds are not free. And, you know, you got to put up the money, or else you got to get a letter of credit or something like that, and it's not free. And that's just another expense that the company must incur to continue to do business and service customers.
Well, I ran a business for 20 years. I bought many bonds over that, so I understand the expense of them. I just was trying to close out this issue today under Chairman McKissick's leadership. And of course, we knew that there was some lack of agreement on the bond. I'll just take that in consideration. The amortization of the capital improvements, did I read somewhere it was 3 years only? Is that for something else, ma'am?
We're trying to get your answer right now.
Well,
I'm just getting a settlement, but,
you can get it later if you need to, sir.
Okay.
It's fine with
We'll
me.
do that. We'll get it to you.
Yes, sir. Thank you.
Are there any questions on commissioners' questions?
I'd just like to add one thing to Commissioner Tucker's question regarding the bond. The company never raised the amount of bond as an issue during, they didn't file a rebuttal, and it wasn't a part of the stipulation. So it was not,
Yeah.
we didn't receive a request for a lesser bond amount.
Sure.
Just as a follow-up, then, how did public staff calculate that the bond needed to be $100,000 when the previous owner only had a $20,000 bond and forfeited that? And I understand you want to cover that, and I understand what the bonds are for, but they are an expense. Just trying to reach a happy medium here, and if they never raise the issue, I understand that as well. Just you know, it's an expense, additional expense, and I just want to know how you calculate 100,000 versus when it was at 20,000.
Well, as to when the initial bond was set at $20,000, circumstances have changed, and the legislature has changed the minimum amount of bond to $25,000. It was $10,000. In terms of the exact calculation of the $100,000 bond, we look at a lot of different criteria, you know, in our assessment of what it should be. And we, and our engineer could better speak to that if you want to call her.
Well, I'm just trying to understand, you know, the calculation from, you know, when the legislature went to 25,000, you're now at 100. If I were in your shoes with all the trouble that you've had with this particular case, this docket, I would certainly want to make sure that I ask for enough to cover any future problems that may occur.
Exactly.
Although, if I read correctly, the new owners have submitted financials and are in better financial shape than the previous owner. So, you know, I'm a former legislator, negotiator in bills and those kind of things, and I understand your perhaps rigidity and not moving off the 100,000. I'm just asking so we can close this out. Is there any opportunity? Mr. Finley mentioned $75,000 bond, which is, you know, 3 times what you had and 50,000 over what the legislature requires. Public staff comfortable with maybe moving to that amount?
We, perhaps it would be opportune time to take a recess,
Okay,
to maybe discuss between the public staff and the company, the bond issue. Chair McKissick, if that would be
Okay.
okay.
yeah,
Uh,
I'm only asking because, excuse me, sir, I interrupt you, go ahead.
The thing I wanted to just be certain of is my understanding, the original bond was like $95,200, but they were not able to raise that amount in terms of the prior operators. Is that factually accurate information based upon the records that you have before you? Or you probably need to go back and check? Okay,
I don't know, but I could check.
all right. Tell you what we will do, at your request, we will go ahead and take a 10-minute recess. And we will resume at, basically, it's 10:38 right now, so 10:48 we'll resume. And they'll give you all a chance to discuss matters. Okay? Thank you.
Thank you.
the record for the remainder of the hearing.
Gotta go.
And I'm going to look to public staff attorney. I believe you have some information to report, and we'd also like to go ahead and get a witness on the stand so we can make certain that we have all of this officially in the record.
In light of the commission's questions,
See what I can do.
we feel that it would be helpful to call Miss Lindsay Darden to the stand.
You said it.
Could you place your left hand on the Bible and raise your right hand? Do you solemnly swear the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And could you state your name for the record?
Lindsay Darden.
Okay, go right ahead.
Lindsay, I know your testimony has been admitted into evidence already, but I think I need to go through the normal introduction as well. Could you please state your name, position for the record?
Lindsay Darden, Utilities Engineer, with the Water Sewer Telephone Division.
And on April 5th, 2024, did you pre-file testimony consisting of 35 pages in question and answer form,
Yes,
an appendix, and 2 exhibits?
yes.
Do you have any changes or corrections to your direct testimony?
No,
And if I were to ask you those same questions today, would your answers be the same?
yes.
Yeah.
All right, Ms. Darden's testimony at my earlier request was admitted into evidence. So if it's okay with you, I will proceed with limited direct.
Feel free to proceed.
Ms. Darden, there have been some questions regarding the public staff's recommended bond amount for this company of $100,000, which was not controverted by the company. Nonetheless, what was the basis for your recommendation of $100,000?
When we consider bond, we look at the size of the system, the complexity of the plant, and the history that the company has in operations. All of these were considered, and this is also a very unique case where there's the interest of the plant is with this mixed use development that has yet to be built. So that's a factor in weighing the risk for the current customers when considering and setting the bond. Also, the current state of the plant, although there's been significant improvements, there's still drastic improvements that need to be made. And that was also considered when we made our recommendation.
Thank you. Commissioner Tucker asked whether or not the public staff would consider a lesser bond, of a lesser amount.
Yes.
And could you state for the record what your understanding of, has the public staff and the company discussed a lower bond amount?
It's my understanding the company and public staff have reached an agreement of setting a bond of $85,000.
So that would, in effect, amend your recommended amount.
Yes.
Amend our settlement agreement
Yes.
to include an $85,000 bond amount.
Yes.
Thank you. Ms. Darden is available for prosecution.
All right, Mr. Finley, do you have any questions?
Yes, yes, please. Chairman McKissick, Ms. Darden, it's, the public staff made a recommendation of $100,000 in its presentation and testimony, correct?
Yes.
But for one reason or another, it was not included in the stipulation, correct?
Correct.
Okay. And as part of its investigation, the public staff looks at the potential owner of a system that's trying to acquire CPCN as to its financial viability and ability to provide service after it receives the CPCN, correct?
Yes,
And you did that and you're satisfied that the owners of this system, GWWTP, does have the financial resources and well-being to continue to operate the system, correct?
yes,
And we're in a situation where we've got 38 residential customers at the moment.
correct.
And we've got a situation where we may be adding additional customers, and we're in a situation where irrespective of whether that additional customers are added or not, substantial improvements need to be made to the system. Is that correct?
Correct.
Okay. Now, it's a fact, is it not, that from time to time, the public staff will go back and look at the bond that exists and has been approved for a particular system, and make a recommendation at the commission that the existing bond be adjusted, correct?
Yes,
And so, as time goes by, the bond, at the recommendation of the public staff or the company, can be to increase the bond or lower the bond, right?
yes, pending circumstances change or risk factors are adjusted.
Right. All right. Thank you for that. No further questions.
All right, Ms. Darden, it's my understanding that this $85,000 bond has now been stipulated to, and that occurred during the recess that we took a few minutes ago. Is that correct?
Yes, that's correct.
All right. Now, have you been at this hearing since it began at approximately 10 a.m.?
Yes,
All right. Did you hear questions which I posed to both the public staff and to Mr. Finley, relating to a variety of matters, either that were contained in the settlement agreement or that might have been omitted from the settlement agreement? Did
Yes.
you hear those questions?
yes.
Is there anything that you would like to state on the record that would provide supplemental information that might be pertinent to those particular questions which I asked, or which you may have feel have perhaps it was omission that was not made by one of the respective attorneys that you would like to provide additional testimony relating to?
The only thing I can think of is just to clarify the questions having to do with the accounting and legal invoices having to do with the CPCN versus the EO. There was a lot of correspondence back and forth with the public staff and the company trying to make that distinction clear, and that was a factor into our calculations and settlement talks.
And what would you like to clarify as it relates to that?
Just that the costs that were included in this case are for the CPCN and doesn't include the emergency operator application.
All right. Are there any other matters beyond that particular issue?
No, not at this time.
All right. Let me see if Commissioner have any questions they'd like to raise. Okay. I'm not seeing any. I will now see if there are any questions on Commissioner questions.
No, sir. None from the company.
All right. Thank you, Ms. Darden. We appreciate you providing testimony today. Now, let me look to both counsel and see if there are any documents or exhibits that need to be included into the record that we have not already included as a part of the record at this time.
We would move the application that has been filed to support the CPCN into the record.
Okay. Without objection, that's allowed.
And if we haven't done earlier, we would move the settlement agreement and stipulation exhibit into evidence.
Okay, without it. Yes, would you like to be heard, Mr. Finley?
Yeah, I hope the commission now has its record about the bond. Apologize for not having that addressed before now, but I will tell you that I'm going to get fired over here if I don't say this. That is that the company feels very strongly about having the bond as low as possible. And I've told Mr. Hauser that the public staff will have the opportunity to look at that bond as we go forward. And he would very much like it be known that the company will continue to look at the bond, and to the extent it's continues to do a good job and make improvements, that it may want to come in and take another look at the bond at some future time. And he's had to convince his owners and investors that this is a thing to do. And we appreciate the willingness of the company and the public staff to settle that issue, and would like to make that known to the commission.
Duly noted as a part of the record. Are there any other matters that we need to address today? I look to both council.
I guess when do you want your proposed order?
Sure. What I was going to request is that proposed orders be filed by June 7th, 2024, if that's acceptable. And that if you want to brief any matters that you feel are appropriate, they should be filed by, well, by that date.
Totally fine.
Does that work for you, Mr. Finley?
Yes, sir.
All right. On that note, we're hereby adjourned. Thank you for your time.